All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140604, Arizona Public Integrity Alliance and Pace Ellsworth versus Maricopa County Special Healthcare District et al. Counsel, we are recording today's proceedings, so as you step to the podium, please identify yourself and the client or clients you represent. Each side will have 20 minutes for argument, and Mr. Lavoie, you're responsible for watching the clock and reserving any time for rebuttal that you might desire, and I assume that the appellees have divided their 20 minutes however they see fit. We have read the briefs, and we've conferenced the case prior to argument. So with those preliminaries, Mr. Lavoie, you may proceed.
Chris Lavoie for appellant. May it please the court. The issue is whether plaintiffs adequately pled a pecuniary loss to taxpayers under Dale v. City of Phoenix. Dale puts forward a three-part test in the alternative. The first test is whether there was a direct expenditure of taxpayer funds.
Let me just interrupt you because something you said at the outset caught my attention. Are you alleging pecuniary loss? Dale talks about three different circumstances. I didn't think that was your allegation, pecuniary loss.
So I was putting all three of those tests under that umbrella heading, but pecuniary loss is what's referenced as transactional loss in the third test, which essentially asks whether the investment was profitable. Did it turn a profit, or is it in the red? So I think, strictly speaking, we just focus on the three tests which are set forth in Dale on just in Head Note 5.
But again, I'm not seeing anywhere in your first amended complaint where you allege pecuniary loss. In paragraph 83, you talk about the use of property tax funds or tax levies. But so that is your claim? Is you're also alleging pecuniary loss?
No, not distinct. I apologize. So I believe under Dale, we are required to allege, at least as to the first test, an expenditure of taxpayer funds. That would be the loss in our view. There's no distinct pecuniary loss separate and apart from that. And so paragraph 83 makes clear in our view that the account from which the $5 million payment to MMIC was made consisted either of taxpayer funds or, in the alternative, a commingling of taxpayer and non-taxpayer funds.
And I think that's where I have a problem with paragraph 83. If you put a period after property tax levy, I think you've got an issue of proof down the road, but you withstand 12b-6. But commingling in and of itself doesn't show taxpayer funds. It only shows taxpayer funds if you can prove through whatever your tracing theories are that really weren't developed fully in the Superior Court. But I think paragraph 83 is concerningly tepid in terms of satisfying the Dale requirements.
Let me be clear that I do not believe, well, I believe that it will be impossible on remand to show that the account had only taxpayer funds. I mean, we believed that at the time, but the most probable scenario is that it consisted of commingled taxpayer and non-taxpayer funds. And so my preference would be that the court not reverse on the basis that paragraph 83 alleges that only taxpayer funds were in the account, because I don't think that's what the proof will most likely be. It was what we thought originally, but we think the most likely situation was that it was commingled taxpayer, non-taxpayer. So at that point, the question becomes, we have, in my view, alleged an expenditure from a commingled account. And what is the significance of that under Dale? Dale did not reach that issue. It was not presented. And in our view, the presumptive tracing rules in Section 59 of the Restatement Third of Restitution should be applied. Let me make the...
I guess, and I think it's more than semantics, but I still think you have to allege that taxpayer funds were used. And then if you can do that in a complaint, then you argue when they move for 12b6 dismissal or summary judgment that, yes, taxpayer funds were used because they were commingled and we can trace, and therefore they're taxpayer funds. They still, under Dale, have to be taxpayer funds. It's not enough that they're just sitting in an account commingled, is it?
This is a point that I think is important to recognize. In our modern electronic net settlement banking system, no money is put in the back of an armored car and transported between banks when a check is honored. Everything is done in a net settlement process at a clearinghouse type institution like the Federal Reserve. So the district writes a check to MMIC for $5 million. $5 million is not put in the back of an armored car.
And that gets to your tracing. I get that. But I want to go back to your response to the motion to dismiss. You say in response to their 12b6 motion that a taxpayer has to show the existence of any one of the three conditions. One, a direct expenditure of funds generated through taxation. Two, an increased levy in tax. Or three, a pecuniary loss. And we've thrown out pecuniary loss. So taking your own recognition of that is what Dale says, don't you have to allege either there's been a direct expenditure of funds generated through taxation, period, or there's been an increased levy in taxes that went towards this expenditure, period. The whole issue of commingling, to me, isn't a matter of proof. You have to be able to plead that these are taxpayer funds.
So I respectfully disagree, Your Honor. What you're asking me to plead is a legal conclusion. I have pled the facts. The facts are that a $5 million payment was made out of a commingled account that consisted of 9% taxpayer funds, and by that percentage, $450,000 of the $5 million was from taxpayers. What you're asking me to put on top of that is the gloss of calling it an expenditure of taxpayer funds, which is a legal conclusion. So what
Cause of
more?
action only exists if they were taxpayer funds.
That's right. But what I think you're suggesting that plaintiff should have done is at the back of paragraph 83 put, and this constituted an expenditure of taxpayer funds, which would just be the gloss of a legal conclusion. I mean, we are required to plead facts under Rule 8. And the fact is that a $5 million payment was made out of the district's deposit account that included taxpayer funds in the approximate percentage of 10% according to the district. Those are the facts. Now, our view is that you can draw the legal conclusion that taxpayer funds were spent when you have an expenditure out of a commingled account. That is the legal conclusion to be drawn. But for the complaint to be dismissed for not pleading, the gloss of a legal conclusion would be improper under Rule 8, which again contemplates the pleading of facts.
Couldn't you allege under what you've just said, put a period after that came from funds derived from the district's property tax levy, period? The or commingled with them, I think, is what creates a problem for you.
Well, I think it's honest pleading.
But so could you just put a period and in good faith Rule 11 standards allege that it came from funds derived from the district's property tax levy, period?
I could. I don't think it would be candid.
What do you mean?
Well, I think the factual situation is that it was commingled. It was either all taxpayer funds or a commingling of taxpayer funds, and in either instance, a payment out of that count constituted an expenditure of taxpayer funds at least to the tune of 9% of the payment.
So if I understand your argument is that because 9% of the funds that were in that account were taxpayer funds, that 9% of them, 9% of the $5 million were taxpayer money.
Logically, if 9% of the funds in that count originated from the tax levy, it naturally follows that 9% of any funds going out of the account are likewise from the tax levy. They're taxpayer funds. So alleging that a payment was made out of a commingled account is the equivalent of alleging an expenditure of taxpayer funds. I think the concern here is that we should have put that sort of conclusory, wrap it with a bow allegation that therefore, or ergo, this was an expenditure of taxpayer funds. But again, that is pleading a legal conclusion, not facts. Let me emphasize that it is impossible for plaintiffs or for any taxpayer to prove that physical currency came from a taxpayer, went to the district's bank, and then went to MMIC. That imagines this cartoon scenario where there's an armored car transporting currency from payor to payee, payor to payee. This all occurs electronically through debits and credits through a net settlement process at clearinghouse banks. So let me give you an example. Imagine a scoreboard in an athletic competition with 5 points on the board, and there's a penalty, and one of your 5 points is taken away. Which of the 5 points was taken away? It's impossible to discern. And that's exactly their argument. They're saying you can't prove, let's say this. Let's say that one of the points was a taxpayer point, and the other 4 points were non-taxpayer points. And then one was taken away as a penalty. Mr. Birnbaum's argument is Mr. Lavoie can't prove whether that 1 point came from the taxpayer point or from the 4 non-taxpayer points. And he's absolutely right. Now, if those points were tennis balls in a bucket that were marked 1, 2, 3, 4, 5, and I reached in and picked one out that was numbered, I could tell. But that's not how the banking process works. It's a digital scoreboard, an electronic ledger. And when the score or the balance total for an account changes, no particular dollars go out the door. It's just like the score on a scoreboard changing. And it's impossible to say that 1 point taken away came from any of the 5. And so if Your Honors were to hold, if the court were to hold that a plaintiff has to physically trace or track coin and currency from a taxpayer to the district's bank and out of the district's bank to the payee, that is an impossibility that will deal the death knell to taxpayer standing because most municipalities have non-taxpayer revenues in their general account. Fees, fines, tuition, that sort of thing. Let me emphasize also that we believe we should have been granted the opportunity for leave to amend if paragraph 83 was inadequate in any respect. I'd like to reserve the remainder of my time. Thank you.
Thank you.
Thank you, Your Honor. Good morning. Gary Birnbaum for the Maricopa County Special Health Care District, and I believe, Your Honor, that my co-appellee has agreed that I can use all of the time, so you'll hear only from me. If that's incorrect, Mr. Sy will jump up right now and say, no, no.
You're doing that.
Your Honor, one of the pleasures of dealing with the Court of Appeals in general is that after you spend hours and hours preparing a logically constructive argument, you then listen to the questions and say, I think I'll put that aside. So let me instead directly respond to each of the questions that has come from the bench directed at Mr. Lavoie. First is an interesting one. Do they have to prove pecuniary loss? That was the first question. And after a bit of, I don't know.
Well, he was getting ready to recite the Dale
Yes, Your Honor.
allegations, and we refocused him to the first allegation where there's a direct expenditure of funds. And so I think Judge Downey, in spite of his preparation and wanting to make his opening statement, laser in on paragraph 83 and what we think may well be the resulting issue, and then he addressed that. So,
Judge Portley, I agree with everything you just said, but there's one piece missing. Is the allegation of pecuniary loss necessary? Well, before we get to Dale, let me point out that the Supreme Court in the Henderson case has said that to sustain a taxpayer standing allegation, to use that as the basis for standing, you must show, and here are the key phrases. Number one, quote, a pecuniary loss, close quote. Number two, which must affirmatively appear, quote, by the complaint, must be alleged in the complaint. And number three, that, quote, such loss will occur. Those are the allegations necessary for taxpayer standing according to the Supreme Court of this state. Now I'll turn to what you just suggested, Judge Portley, and which we anticipated, and that is...
So you think Henderson controls Dale?
Well, first, yes, I think Henderson controls Dale. Yes, I with all due respect to this honorable court, yes, I think the Supreme Court's crystal clear statement remains the law of the state.
But they're not inconsistent, are they?
Well, they might be. And as you pointed out, Judge Downey, there actually is no allegation of pecuniary loss, either using that term or suggesting otherwise in this case. But allow me to go on, because I know this is the focus. It was the focus of your questions, and it's the focus of our response. Let's assume that there's three ways that you can show pecuniary loss. That you don't have to allege it using those words, that you don't have to directly meet Henderson. And let's say that Dale is consistent with Henderson, and that Dale says there are three ways that pecuniary loss might be shown. It is not surprising to me, or I suspect to the court, that we have spent no time so far on factor 3, which is the allegation of an actual loss, because the complaint itself in 6 or 7 different places alleges that this is a lucrative contract, that is the contract that MMIC has obtained, that will generate profits and help offset other expenses of the district. So they not only don't allege a loss, they allege a highly profitable investment. Number 2, we also don't talk at all about the second factor in Dale, because that is that you have to show a tax levy increase resulting from the challenged expenditure. Well, the only thing the complaint even alleges is here is the amount of the tax levy in each of a series of years, without the slightest allegation that it is even affected, let alone increased, as a consequence of this investment. So we are then back to your focus, which you presented to Mr. Lavoie, which is what about this direct expenditure? Can you allege and can you prove a direct expenditure? Mr. Lavoie is a fine lawyer and an honest man and has been throughout this case, so he told you the truth. He said, 1, Mr. Birnbaum is correct. Number 2, we cannot prove a direct expenditure. Number 3, despite Judge Downey's effort to edit the complaint in a way that doesn't appear, he said, we can't even allege a direct expenditure. There is not the slightest basis for saying the taxpayer money was used here. That should be the ending point of the discussion. But let's assume it's the starting point. Mr. Lavoie says, well, I should be able to exercise a presumption that taxpayer money was used. A presumption which, I will point out to this court, appears absolutely nowhere in Arizona law ever, particularly not in the standing context, and which, with all due respect, Judge Downey and Judge Portley, I would suggest to you is directly contrary to the language of Henderson, which requires, again, affirmative allegation of a pecuniary loss in the complaint and the allegation that such loss will occur. It doesn't say you can somehow magically presume that there is such a loss. But let's go a step further. Now let's respond to even the possibility that, well, forget Henderson, why can't we just come up with a presumption? Well, the presumption they want you to use is, first, he said twice, 9% of the money in the district's accounts comes from taxes. We don't actually even know that. We know the district brings in $50-some-odd million in taxes, and that its total revenues from all sources, as you all know, it operates the largest public health care system in the state, is substantially in excess of $500 million. That's what we know. And he says, well, see, 9% of the total revenues of the district, if you do that computation, could be tax money. On a piece of paper, on a financial statement, we do have tax revenues, we do have other revenues. He says, so 9% of every dollar spent, it's called the proportionality test, 9% must come from that money. That test is not and has never been the law in Arizona, in my mind, for any purpose, but I am quite confident, based on our research, it is not and has never been the law for standing purposes, let alone taxpayer standing, in light of Henderson, where they want you to adopt this proportionality rule, which is not the law and does not comport with Henderson.
On that point, I think I heard Mr. Lavoie say near the end of his argument that most municipalities have taxpayer funds in their accounts. If we were to say that any taxpayer funds commingled with other funds were sufficient to grant standing, what effect would that have on our standing jurisprudence?
Well, it would be contrary to Henderson and Dale.
Wouldn't it give taxpayer standing in virtually any instance if, as Mr. Lavoie says, most municipalities commingle taxpayer funds with other funds?
Assuming that Mr. Lavoie's evidence is evidence, which it's not, and it's not even an allegation in the complaint, but assuming that was true, Your Honor, you would have exactly the analysis set forth in Henderson and in, I believe the case is Bennett versus Napolitano, where this court has said, and the Supreme Court in Henderson has said, think of the mischief that is done if you open the floodgates to every single taxpayer to challenge essentially every government action, because that's what you would have. In fact, let me point out that arguably that would be Dale itself. That would be Henderson. Any expenditure made from an account that has had any tax money flow through the account, think of the state level, the state of Arizona General Fund. I won't ask you to take judicial notice of it, but it's got a lot of tax money in it, all right, whether it's property tax or income tax or otherwise. That means that every taxpayer of the state has standing, at least, to challenge every expenditure of the state legislature. It's not the law. It's never been the law. It's really bad public policy. And if the legislature decides someday to adopt such a mistaken view, well, so be it. But that's not where we are today. But then, finally, Your Honor, a point I have not touched on, but Mr. Lavoie did. Now, the colorful example of, I forgot what it was already, baseballs or tennis balls in a bag. Okay? Here's a problem with that example, two problems. Number one, it is not the law of Arizona, has never been. Number two, he wants to import a concept from the law of restitution that is designed to protect wrongdoers victims against fraud or tortious conduct by a wrongdoer. So he references Section 59 of the Restatement of Restitution and Unjust Enrichment, which of course also has nothing to do with standing. That restatement section, again, I'm going to make another assumption that even that should be applied. Here's the problems with that section. Number one, it's not the law in Arizona. Number two, it expressly rejects the concept of proportionality. In fact, it goes so far as to say that used to exist in the prior versions of the restatement. We deny its propriety today. We are changing the law. And then rather than utilize a lengthy legal lawyer's argument, let me give you the colorful example, which comes out of the reporter's note, Note D, to Section 59 of the Restatement of Restitution. And I really don't want you to make the mistake of thinking I believe that restatement has anything to do with this case. It doesn't. But here's the colorful example taken from an old English case. You can tell from the language. Quote, "The simplest case put is the mingling of trust monies in a bag with money of the trustee's own. Suppose he has 100 sovereigns in a bag, and he adds to them another 100 sovereigns of his own, so that they are commingled in such a way that they cannot be distinguished. And the next day, he draws out for his own purposes 100 pounds. Is it tolerable for anybody to allege that what he drew out was the first 100 pounds, the trust money, and that he misappropriated it and left his own 100 pounds in the bag? It is obvious he must have taken that which he had a right to take away, his own 100 pounds. I hope that's clear. I know it's hard to read quotations, but let me interpret, if I may. If you adopted a presumption, if you looked to the restatement, if you ignored the inconsistency with Henderson, what does the Restatement of Restitution say? It says if you have $100 of mine and $100 of yours in an account, when I remove $100, we assume I'm removing mine so that your money remains in the account where you can trace it and recover it if necessary. If you now change the words to if the district has $100 in an account and of non-taxpayer money and $100 of taxpayer money, and the district withdraws $100, you assume the district rightfully withdrew its own money so that the operational money, so that the $100 of taxpayer money remains in the account. So
Aren't all of those tracing theories and the restatement issues proof issues versus pleading issues? I mean, you know, we are here on a 12b6, and I understand what you're saying, that in an ultimate proof setting, those would come into play, but aren't we just focusing now on whether the complaint sufficiently alleges any of the things that Dale says must be alleged?
Thank you, Your Honor. Your Honor, with all due respect, we would be if Mr. Lavoie was not honest about his allegations and what he can prove. You could, as you suggested, perhaps under some contorted theory that was not advanced below, you could perhaps take that paragraph 83 and say, well, couldn't I abbreviate it and truncate it and make it say something that it doesn't say? And Mr. Lavoie honestly says to you, no, you can't. You can't, because we know the district has one commingled account. We know there is no account that has just taxpayer revenue in it. And that's why he says, so I admit I cannot show an expenditure of taxpayer funds. I admit it, Birnbaum is correct. All right, then he says, but I'd like you to somehow or other find that I can apply Henderson and you can take my allegation, avoid Henderson, and somehow read my allegation to be sufficient because there are tracing theories that I want you to import into my allegation. Well, besides all the reasons you cannot and should not do that, the fact is, I'm pointing out that even if he were correct, and you could use tracing as an inferred presumptive part of the allegation to try to find standing, then, I'm telling you, they're wrong about tracing. It's not only not the law in this state, there is no presumptive tracing. It would violate Henderson, but I'm going further. And I'm telling you, if I was wrong about all of that, they misapply the tracing rules, even if they were applicable. There is no way that paragraph 83 of the complaint, there is no way that that can be found to comply with Dale, and certainly not with Henderson if that adds an additional gloss onto Dale.
So your argument is that it fails to state a claim upon which relief can be granted for the reasons you've discussed, and that leave to amend would be futile because of these other reasons.
Yeah, on your first point, Your Honor, a simple way to say it is that while you're of course not bound by Judge Reyes's minute entry, the judge's view of paragraph 83 below is absolutely correct on all points, including the cases it cites and the reasons given. As to the second point, I'll use my 2 minutes to discuss leave to amend. Here's the problem with their request to amend. They didn't ask for it the way you need to ask for it. They didn't ask for it in the form you need to ask for it, and they gave no indication whatsoever that amendment would not be futile. So let's just take them in pieces. First, leave to amend needs to be made by motion. That's rule, I believe, 7.1. Second, that rule is a strong word, but it's absolute because it was interpreted in the case of Blumenthal versus Tietz, which we submit is precisely on point. And Blumenthal was an effort to seek leave to amend by just throwing a line in a brief or a motion or a response that says, well, if my position is denied, I move for leave to amend. Court said, absolutely not, that is insufficient. That does not comply with Rule 7. But then since then, we've amended Rule 15. So now, 15A2, I believe it is. So now, if you seek leave to amend, you have to give the court an interlineated, annotated copy of your amended pleading so the court can see what changes you're seeking to make and why. They didn't do that either, at any time, right up through today. It has never happened. So they violate 7.1, Blumenthal versus Tietz, and Rule 15, and then substantively, what does that mean? That means that the Judge Reyes, had no basis for figuring out what it was they might say in their amended pleading. He had no basis, and therefore he found that based on what was before him, amendment would be futile, untimely and futile. And again, we respectfully submit that the judge was absolutely correct in that finding, and he didn't even have an amended complaint to look at to say, well, I'm going to examine what they said. So again, we believe the trial court was correct in all respects. Thank you very much for your time, Your Honor.
Thank you. Rebuttal, Mr. Lavoie?
Thank you, Your Honor. Paragraph 83 should be read as alleging that the $5 million payment was made out of an account commingled with taxpayer and non-taxpayer funds. That's what plaintiff will be in a position to prove. The question is a legal one at that point. If a payment is made out of an account commingled with taxpayer and non-taxpayer funds, does that constitute a direct expenditure of taxpayer funds under Dale's first test? That is the legal question before the court. A commingled account is the most that plaintiffs can ever allege, and it's the most, we respectfully submit, that any taxpayer could allege in any case, or at least almost all cases, because almost all municipalities commingle taxpayer and non-taxpayer funds in their fisc.
But if we accept your argument, doesn't that then open the floodgates literally to challenge, as Mr. Birnbaum posited, virtually any expenditure from a general fund, because that includes
No.
some taxpayer funds? Why?
Because what the municipalities should do, or can do, if they don't like that result, is segregate. They need only create a second account in which only taxpayer funds are deposited, non-taxpayer revenues are placed in a separate account.
But
And
it wouldn't just be municipalities. You're saying the state general fund couldn't exist as is, because it would be subject to challenge for any expenditure the legislature approved.
you could have sub-accounts. So let me make the point that if you were trying to be strategic as a municipality and avoid taxpayer lawsuits, you would say, well, I'm going to create a separate account or a separate sub-account within a general account, and I will state on the checks or on the warrants which account or sub-account it comes from. And I will be very careful about what I use monies out of the taxpayer account for. If I were, I wouldn't use them on an unconstitutional investment to buy a security in a startup insurance company.
And if the legislature wanted to dictate that kind of procedure, presumably it could, but what you're suggesting does not seem consistent with the Henderson-Dale jurisprudence.
The issue that is raised here has never been presented in any prior case in Arizona. It is not squarely raised in Henderson nor in Dale. There has never been a situation of a commingled account that has come before an Arizona court, and you can't infer from cases that make general statements how the courts might have dealt with the more nuanced situation of a commingled. Now, in Dale, there's no evidence that the payments were made out of a commingled account. What Dale says is that the revenues that the water system generated were used to pay the purchase price. There's no evidence that the payments were made out of a general fund that was commingled with taxpayer and non-taxpayer funds. And so what I'm in effect suggesting is a compromise. So if payments are made out of commingled accounts, the proportionality rule should apply. And paragraph 83 would be adequate under the proportionality rule that Mr. Birnbaum described. If 9% of the taxpayer revenues come, 9% of the account funds come from the tax levy, then the proportionality rule would hold that 9% of the payment, or $450,000 here, came from taxpayer funds. If municipalities don't want to be subject to the proportionality rule, then create a segregated account or sub-account in which taxpayer funds are deposited, and be very careful about how you spend that money. And if you don't want a constitutional challenge about investing public monies in startup companies, pay it out of the other account that doesn't have taxpayer funds. This was easily avoided. Mr. Birnbaum says that we're the one who invented and repeatedly used the 9% figure. That is untrue. At every stage of this proceeding, at every opportunity, defendants have trumpeted the fact that only 9% of their revenues come from the tax levy. And they do that to suggest that there's no way the entire $5 million came from the tax levy. We agree. In terms of probabilities, the entire $5 million didn't, but 9% did. And when the 9% figure boomeranged on them, now they're saying that it's our number. It's not. And it's in the very records. It's in their admissions in the pleadings. I mean, which are...
Theory, the number doesn't really matter. It's the fact of the commingled.
Well, I suppose. So, you could make an argument that some de minimis percentage at some point is just too remote and speculative. But 9% is not it. I mean, if we were down at 0.5% or 1%, that becomes a more complicated issue. Or if a larger percentage applied to a smaller number only yielded a de minimis sum of money, like $100, then that becomes a more difficult question. But we're not presented with either of those. 9% of $5 million is $450,000, which under any theory is significant and worthy of constitutional scrutiny.
Before you run out of time, Mr. Birnbaum refocused my attention on the language in Henderson about requiring a pecuniary loss to taxpayers. Talk to us about that and where in the complaint that's been sufficiently alleged.
Satisfying any of the three tests satisfies the pecuniary loss test. It is not independent. These are specific
Court of
articulations.
Appeals, maybe, but does the Supreme Court say that? I mean, and that's kind of what I was looking at, and obviously we bow down to their jurisprudence, and they say several times in Henderson that absence of proof of pecuniary loss to taxpayers is fatal. So what are we to make of that?
$5 million out of an account constituted of 9% of taxpayer funds is a pecuniary loss to the public treasury. It is inconceivable that at least some taxpayer funds didn't go with that $5 million. If you
Loss, so that just means an expenditure. I mean, loss implies
Well,
a net.
let me say,
loss.
I think it is a loss, but if you're going on Mr. Birnbaum's theory of a transactional loss, which is really the third test in Dale, the undisputed evidence in this case is that the district has not recovered its $5 million. Its 2014 budget.
And that's proof, but I guess I'm looking back at
Well,
the complaint.
but-
Where do we
hold on.
look in your complaint besides paragraph 83?
It's not in my complaint. We acknowledge that we did not plead a transactional loss for the third test. But one of the points that we made in our reply brief, and we cited case law in a footnote, is that just as a court may take judicial notice of documents outside the four corners of the complaint for purposes of dismissing a complaint or finding that it doesn't state a claim, it may consider a document outside the complaint for upholding a claim. And it's a two-way street. Considering extrinsic materials may be for either upholding or dismissing a complaint, finding that it either does or doesn't state a claim. I mean, if there is, let's suppose that a complaint is missing an essential allegation, but there is a document authored by the defendant that's undisputed that the court can take judicial notice of that shows that missing allegation, the court can take judicial notice of it to uphold the complaint.
Your time's up, so if you want to sum up, that'd be great.
Thank you very much. Let me emphasize, they want a presumption that no taxpayer funds came out of that account with that payment. They're the ones asking for a presumption. Someone, I mean, there is no way to trace physically money here. So thank you very much, Your Honors.
Thank you. Thank you for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess pending our next hearing. Thank you.